25 CR 128, People versus Barry Morphew. Mr. Morphew is present in the courtroom with his counsel. Ms. Kelly and Mr. Johnson are present on behalf of the state. I have a motion to reduce bond in front of me. Ms. Kelly, anything else the prosecution is hoping to accomplish today?
Nothing from the report, Judge.
Mr. Kelly?
Thank you, Your Honor. Your Honor, as the court knows, this matter is also set for status, and so I do anticipate advising the court briefly of sort of what the parties have discussed regarding timing, other than the timing issue.
Excuse me just a moment. If you are on the WebEx, you need to make sure you remain muted the entire time. If you don't remain muted, you may be removed from the WebEx room. My apologies, Mr. Billy.
Not at all, thank you. Your Honor, other than the timing issue and the bond issue, I do not believe that there's anything else that I have planned on addressing today.
Okay.
Thank you.
Mr. Biller, as it is Mr. Morphew's motion, do you have any witnesses you want to present with regard to the bond issue?
We do not have witnesses, Your Honor. I will simply be making an oral argument. I would note for the court, however, that Mr. and Mrs. Morphew's two daughters are also present in court today.
My apologies, yes, I did notice that. All right, and I will note that several of the victims are also present on the line.
Understood.
Ms. Kelly, do you have any witnesses you all wish to present with regard to the bond issue?
No witnesses, just for one, Judge.
Okay, Mr. Beller, whenever you're ready.
Thank you, Your Honor. Your Honor, I have already set forth the statutory factors and the constitutional factors, of course, in my written motion, and I am not going to go through and recite those. But in making an argument, I believe that there's several things that the court should take into consideration. Your Honor, I very much believe, and Ms. Byrie also very much believes, that we have an innocent client that we are representing. I say that not just constitutionally, Your Honor, and of course the court knows that there is a presumption of innocence, but also we have factual innocence. And while I understand that this is not a proof evident presumption great hearing, I do believe that it is important for the court to at least take into consideration the perspective of the defense coming in to representing Mr. Morphew and in arguing this motion. Your Honor, as the court knows, several years ago, the evidence was heard in a proof evident presumption great hearing, and ultimately Mr. Morphew was determined to be eligible for bond in a time and in an era where, candidly, that is relatively unheard of. The law, of course, has changed since then, but Mr. Morphew, through both grand jury, is not entitled to proof evident presumption great, and ultimately statutorily for the time period in which the offense is alleged to have committed is not entitled to proof evident presumption great. But that track record, I believe, is telling and is something that the court should and can change in or take into account. And I admit that the evidence has changed to the slightest degree. Of course, thankfully, with the discovery of Ms. Morphew's body, but importantly, the substantive evidence and the problem that the government has had in finding the proper person responsible for this offense, Your Honor. The evidence itself has not changed, although the theory of the government has, and that has been ever evolving. Your Honor, the evidence of Mr. Morphew's innocence is substantial, and I think through the coming months the court will see that when the time is ultimately proper. But in deciding whether or not to reduce Mr. Morphew's bond from $3 million to what the defense is asking for, which is $500,000, the court should take into consideration and can take into consideration Mr. Morphew's past conduct. We know, Your Honor, that Mr. Morphew was released on a $500,000 bond. And throughout the litigation of Mr. Morphew's case, Ms. Morphew's unfortunate death, Mr. Morphew did exactly what bond is supposed to do, which is that Mr. Morphew appeared for every single court appearance. He followed every single requirement of the court, and at no time had any problems complying with the orders of the court. And there is nothing about the evidence, and there is nothing about the charge that has ultimately changed that. Your Honor, Mr. Morphew, while living in Arizona at the time of this second arrest, it doesn't change the fact that he has substantial ties to the community. Those ties, in many ways, are spelled out in the motion, and I'm not going to go through and recite those. But Mr. Morphew obviously maintains an incredibly close relationship with both of his daughters, statutory and even non-statutory victims in all sense of the word. That is compelling for him to continue to comply with orders of this court and ultimately see this case through to its legal conclusion. His mother, of course, he remains very, very close with. And then Mr. Morphew has countless friends that are also in the area. Mr. Morphew has established, as stated in the motion, a place to be able to stay here in Colorado, should the court determine that that is most appropriate, or if the court were to permit him to return home to Arizona. He also has a home in Arizona with substantial ties to Arizona, noting, of course, that he did return to Colorado when he was supposed to in other proceedings. Your Honor, Mr. Morphew has had counsel on this matter for 5 years, since the loss of his wife. Counsel has maintained and remained in contact with the prosecution during that entire period of time. And so even when there were no active judicial proceedings, counsel for Mr. Morphew stayed in contact with the people such that Mr. Morphew's whereabouts were known at all times. Mr. Morphew certainly had the legal right to be able to leave the country if he wanted to. He had the legal right to maintain anonymity if he wanted to and if he chose, but Mr. Morphew did not do that. That is important because even when Mr. Morphew had absolutely zero legal ties to this jurisdiction, we remained in contact with the prosecution that entire period of time. As the court knows, when an individual is unable to post a bond, that is an indication for the court that the bond is set too high. Bond, as the court knows, and I will not waste your time reciting law to you that the court already knows, is done for the purpose not in determining guilt or innocence, but is done for the purpose of making sure that somebody comes to court, answers to court, is accountable through due process. And the fact that Mr. Morphew's bond is at $3 million and has been since June, and Mr. Morphew has not been able to bond out, is an indication that the bond is set too high. And ultimately, in this case, Your Honor, there is little to no justification in my mind as to if the question of if $500,000 was enough to ensure Mr. Morphew's compliance, and did, in fact, ensure his compliance without single failure, why then is $3 million the appropriate amount to be set now? Your Honor, candidly, Mr. Morphew does not have the same financial assets that he did several years ago. Certainly not in 2020 or even in 2023. $500,000 was much more accessible to him several years ago, and ultimately he was able to pay that. Mr. Morphew is now in a much different financial situation than what he was before. And so $500,000, which is the request of the defense, while high enough last time to ensure his compliance, I would argue now is even that much higher for him because it's going to be that much more difficult for him to be able to come up with those sorts of funds. And candidly, there's going to be a lot more people who are assisting Mr. Morphew ultimately with their own accountability to both the funds as well as to this court. And so under the circumstances, Your Honor, and for all of the statutory reasons cited in the motion, as well as the oral motion made today, I would ask the court to consider reducing his bond from $3 million cash only to $500,000 cash only, with any other requirements that the court may require, ultimately requesting the court allow Mr. Morphew to reside in Arizona, but even if the court determines that that is of too high a risk to the court, certainly Mr. Morphew is more than willing and happy to remain in the jurisdiction and in Colorado should the court consider a reduced bond. Thank you.
I have some questions, Mr. Bowler.
Yes, please.
First of all, and you don't need to use proper names, but
Understood.
you said that Mr. Morphew has substantial ties to this community. From my perspective, this community is essentially the 12th Judicial District.
Absolutely.
Does he have ties to this judicial district?
Your Honor, to be fair, the answer is no. We'd be talking about neighboring jurisdictions, directly neighboring jurisdictions. As the court knows, this matter is currently being heard and held in Alamosa, although arguably Saguache County would be the proper jurisdiction. That's something that we can discuss later. Ultimately, I would say to the court that the proper jurisdiction is Saguache. But even then, I cannot and will not represent to the court that Mr. Morphew in that very, I think, rural jurisdiction has substantial ties to the 12th necessarily, but rather to neighboring jurisdictions.
And you stated in your motion that Mr. Morphew, when not in custody, is employed. Is he self-employed or does he work for a company?
Your Honor, he was self-employed. We do have contacts within not this jurisdiction, but neighboring jurisdictions, many of whom have indicated that they would be willing to employ Mr. Morphew, but I will not represent to the court that that is ultimately lined up at this point for very obvious reasons. But we have no doubt that employment will certainly be possible upon his release.
If you know, how long did Mr. Morphew remain in Colorado following the dismissal of his previous case?
Not long, Your Honor. Mr. Morphew, and I do believe that this has already been reported, and I'm happy to answer. After the dismissal, Mr. Morphew stayed in Colorado for a very brief period of time. He then relocated to Indiana and was very close with his mother in Indiana. Ultimately, he went to Arizona with other family members and remained in Arizona after that time with other family members.
And since that time, has, other than Colorado, Arizona, and Indiana, has he been present in any other state for 2 or 3 weeks or more?
Only to relocate family members who were relocating, other than short trips for the purpose of relocating those individuals. The answer is no, and so far as I'm aware, it hasn't remained in those 3 jurisdictions the entire time.
And again, you don't have to use specifics or proper names, but to your knowledge, has Mr. Morphew used any other names than that which appears on his birth certificate since his last case was dismissed?
Yes, Your Honor, and I'm happy to answer this question. Mr. Morphew's middle name is Lee, and he has introduced himself and used his middle name from time to time for very obvious reasons.
Okay, thank you.
Yes, thank you.
Ms. Kelly or Mr. Chapman?